Everyone ready to pick back up at 1:45?
Yep.
Ready.
I'm ready.
All right, good afternoon, everyone. I'm Commissioner Easton, and this is my afternoon calendar. Before we get started, I see that there is an AI bot that was admitted with everyone else. I don't admit or allow AI note takers because it's my understanding that they record items, and the only official recording that's to be allowed are the official recorder. So does anyone wish to claim and explain why there's an Augie, OGGIE,
Yeah,
native
Your Honor.
AI?
Yeah, it's my fault. I will remove it.
Oh, I can do that for you, sir. All right.
Sorry,
So-
it's automatic thing that I have no idea it was there.
No worries. So I'm going to go ahead and call the first matter for 1:45. This is the time set for in the matter of AZTS1 LLC versus Kamisha Latrice Whitmore, case number CB 2026-029656. Can I get appearances, please? Being counsel for the plaintiff.
Good afternoon, Your Honor. I'm Isaac Helene, appearing for attorney Lily Pedersen on behalf of plaintiff AZTS1 LLC.
Good afternoon. Do we have, it looks like we have a representative from AZTS1 LLC. Is that correct?
Yes, Your Honor.
Right. Can you introduce yourself, sir?
My name is Augie Penef. I'm a member of the LLC.
Okay. Well, counsel, it looks like the other individual in our courtroom, either my court staff, the recorder, or Miss Weir, and I see that she is a party for my 2 o'clock. So it does not appear that any defendant or defendant's attorney are timely appearing, which is not much of a surprise since I saw the non-served declaration. So how are you seeking to proceed today, sir?
Yes, Your Honor. If the court will allow it, I would like to make an oral motion for alternative service under Rule 4.1K. And in conjunction with that, I'd like to request a continuance of this hearing for the court's first available date, allowing for some time to accomplish service.
Okay, well, why don't you go ahead and it's a little atypical, but I don't think it's not disallowed to have oral motions for alt service. So why don't you go ahead and make your argument today, sir?
All right, thank you, Your Honor. our position is primarily based on Exhibit 4, which was submitted prior to this hearing, which is that declaration of non-service by plaintiff's private process server. And as you can see from that declaration, the private process server attempted service on 4 different days at different times and was unable to make contact with any person at the property. So based on, the fact that there was no answer, no noise, plaintiff believes it would be most conducive to providing notice to mail the documents as required by Rule 4.1K, as well as posting the documents to the front door of the property.
Okay. And I do have the declaration of service for the record. Looks like your process server attempted to serve on July 29, which is a Wednesday at 4:51, July 30th, a Thursday in the morning at 11:05 a.m. Friday, July 31st at 10 a.m. and then even tried on a weekend, the August 2nd, which was a Sunday at 7:10 p.m., all with no answer. Am I reading this correctly, counsel?
That is correct, Your Honor.
Well, I think based upon your oral motion and the declaration of non-service by a private process server that was filed August 4th of 2026, I do find that you've met your burden, and I will grant your oral motion for alternate service. And I do see that you've provided a form order for me for mailing at the address and then posting at the address subject to this eviction matter. So I will go ahead and grant that and enter the record here today. So with that, so your oral motion for alt service is granted. The order will be has been signed and will be filed momentarily. So with that, you also had a motion, I believe you hinted at a motion to continue as well.
Yes, Your Honor.
How long do you think you're going to need?
I think if the court has availability towards the end of next week, that should suffice for accomplishing service. So maybe the 13th or 14th.
Miguel, what do we have? Looks like we got some time Friday afternoon, the 14th. Miguel, what do you think?
Correct. We could do the 13th at 2 or 14th. Maybe like 3 p.m.
Yeah, let's shoot. Does Friday, August 14th at 3 p.m. work for you, counsel?
Let me double check. Yes, Your Honor, that'll work.
My Thursday is a little full. Friday is marginally better, so I'm going to grant your oral motion to continue today's hearing, resetting today's initial appearance in this eviction matter to Friday, August 14, before this division, virtual for 3 p.m. Okay?
Thank you, Your Honor.
All right. Anything else we got to talk about today, sir?
Nothing further.
All right. Well, if there's nothing else, then this matter is adjourned. Have a good rest of your day, okay?
Thank you. You too.
And don't think I'm being rude. I do see other people here for my future matters. I will call those matters at the appointed time. I am going to turn off my camera and microphone because I'm going to try and get some other work done, and no one needs to see the top of my head while I do other things. So thanks. All right, so it's 2 o'clock. Let's go ahead and call in the matter of Lux Limited Company versus Cindy Weir et al. Case number CV 2026-028750. Let's go ahead and get appearances, please. Beginning with counsel for the plaintiff.
Your Honor, thank you. Mark Hildenbrand for the Plaintiff Lux Limited Company.
Good afternoon, counsel. I did see that you provided a copy of your notice of appearance to my division. Looks like it was dated yesterday.
Correct. And I also emailed a copy to Ms. Weir. It was obviously late last night. My apologies for that. I didn't get a lot of notice of what was happening. So nice to
Well,
finally meet you, by the way.
Good afternoon to you, sir. Ms. Weir, let's go ahead and get you to first unmute yourself because I want to hear from you. And then go ahead and introduce yourself by saying your name, please.
My name is Cindy Weir. I'm the defendant for this eviction pro se.
Okay. Well, Ms. Weir, because you are self-represented, you're not a licensed attorney. Mr. Hildenbrand is, so he's subject to a whole bunch of slew of regulations for the state bar. So I'm going to ask that you please raise your right hand, and because my clerk's going to swear you in, okay?
Okay.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, thank you. Go ahead and put your arm down now. So this is the time set for a continuation of an initial appearance in an eviction matter. I hope the parties are ready to proceed. And just to give everyone a quick heads up, I do like to follow what's found under Rule 11. So I'm going to first ask the plaintiff's counsel to state or summarize the material allegations of the complaint. Ms. Weir, I'm going to ask that you listen carefully, and then I'm going to ask how you plead, even though I think I have an idea of how you're going to, because I see that you have an answer and counterclaims on file, but it never hurts to follow the rules as written. So if no one else has anything else they want to bring to my attention first, let's go ahead and continue with the initial appearance. So Mr. Hildenbrand, please state or explain the material allegations of the complaint, sir.
Thank you, Your Honor. But basically, my understanding is that Ms. Weir was allowed into the property on a month-to-month basis, that there's no written lease agreement between the parties. Contrary to the allegations of the complaint and the ledger that was supplied by prior counsel, my client indicates that he has not received rent since June of 2025. And the monthly rent would be consisting of, I believe, $1,300 base rent and $150 per month for utilities. So at some point, it does appear to me as if I will need to either orally or otherwise move to amend the complaint to reflect the accuracy of that. I don't know, I can't speak for prior counsel at all, but just today, I mean, moments ago, I was talking to Mr. Lunn, which is the member of the LLC, and he indicated to me that he has not been in any kind of communication with Ms. Weir for quite some time, and that the last time he received rent was May of 2025. So that's substantially different than the complaint's allegations. I wanted to just make sure that you're clear on that. Ms. Weir was served a notice in court for non-payment of rent. I have been told, and I have not seen this, but I've been told that she was also served a 30-day notice to vacate or to terminate the month-to-month tenancy. I have not been able to confirm that with prior counsel, and I don't know that I could tell you that my client is anything but potentially confused about what the meaning of the notice was. That was the 5-day notice for non-payment of rent. And so as soon as I do, get the real story on that, I don't want to misrepresent to the court anything. I just want to make sure that you know that that allegation has been made, not in the pleadings, but by my client. That would certainly change our version of what needs to be in the complaint as well. And I'm sorry to say that, or I apologize for the delay in that. I don't believe I had anything to do with it, but I'm still apologizing. She's currently, just to kind of finalize things, she's currently in the unit, at least in one of them, if not more. There's 4 on the property, and has not vacated. We believe that the evidence will show that she is behind in her rent, that she doesn't have a legitimate defense to those allegations, and that we should be entitled to legal possession with a writ to issue, as well as an award of attorney's fees, court costs, attorney's fees pursuant to 12-341-01, not pursuant to a written contract, taxable court costs, and the rent that would be $1,450 from June 2025 per month until today's month, which would be August of 2026. I appreciate you taking the time to listen to that.
Of course, counsel. We'll refer your attention to Rule 11F of the Arizona Rules of Procedure for Eviction Actions. Except for those additional damage items contemplated in Rule 13C2, the plaintiff shall not be permitted to advance allegations at the initial appearance or any subsequent trial unless the allegations were properly stated in the complaint.
Yes, I understand that.
So I just want to put that in the water supply. I'm not making any findings at this moment, but just wanted to let everyone know what I'm thinking.
Oh, okay. Would you also be either able or willing to expand on your position as to an amendment of the complaint, whether it be oral or written?
Well, the complaint's got to be written.
Yes.
I mean, Rule 9 has the rules, outlines the specific rules for motions. And I'm not going to comment on any motion that is not even before me, even orally. You're just, I recognize Rule 9 exists.
I appreciate it, Your Honor. Thank you for that.
So, Mr. Hildenbrand, anything else before I turn over to Ms. Weir?
No, Your Honor. No, thank you.
All right, thank you. Well, Ms. Weir, as promised, it's now your turn. So I'm going to ask how you plead, and whether you contest any of the allegations. And again, I do have your answer. So you don't need to read your answer if that's what you, but I do must ask how you plead, and I would like to know if you contest anything. And if you, so take it away, Ms. Weir.
Okay, I'm pleading that I do not owe rent. I paid, my receipts will show that I paid through July. Not, I didn't pay all of July, but I made a payment in July that would cover partial July. The rent was not $1,300 plus $150. It was $1,400 plus $150. The receipts show that. Also, I moved in late January with a partial payment and a $900 deposit, and then made sporadic payments from then through July, and they'll add up to $1,450 or $1,400 plus $150 for utilities. Anyways, I was never given a 30-day notice, ever. I'm not sure what all I need to state right now. A month after I moved in, I seriously damaged my foot, and I tried to inform Mr. Lynn, and he completely ignored me. On a couple of different occasions via text when he initiated the conversation. And he did put a heart on my foot, though, whenever I sent him a picture of my foot, which one of them was clearly twice the size of the other one. He's ignored my attorney. I mean, I wore a boot for 3 months and was in physical therapy for 2 additional months. And from there, I filed complaints with the city. It was before June, but the ones that I submitted in my defense was the ones from June from the ombudsman, that the stairs are not code. There's several different other code violations that are pretty serious, and some of them life safety issues. I'm trying to think. The refrigerator hasn't worked since I moved in. He told me he would fix it, never did. There's a slew of different problems that are all that I mentioned in my complaint. So I feel that my damages would offset any rent that he feels that I owe.
Based upon my review of both the complaint, counsel's statements, and then Ms. Weir, your statements, and then your filed answer, which it sounds like that's what you're relying upon, in addition to your oral statements here. The court finds there is a triable issue, since neither party has requested a jury trial prior to me saying this now. So I'm going to set it for a bench trial. So everyone bust out your calendars. I know under the rules, we've got to set this within 10 days. I can squeeze in some time, but I've got limited availability. We civil commissioners, there's only 5 of us for the entire county. And we deal in volume, and my dance card is pretty full in addition to some other personal things I've got going on that I won't bore you guys with. So first off, let me throw it to the parties. How long do you think you're going to need for a bench trial?
Gosh, I don't even know. I don't know. I'm not an attorney, so I have no idea how long it'll take. You see my evidence that I have to present, so.
Well, Ms. Weir, how many witnesses do you intend to call?
I'll say 5. Do I have to be exact right at this moment?
At this point, no, but
Okay.
if you're intending to call 5 witnesses, and then Mr. Hildenbrand, I'm assuming you're going to call, how many witnesses do you intend to call?
1 or 2 at the most, Your Honor.
2. So 7 witnesses. I was thinking we could have hopefully got this done in half a day, but if that seems rather aggressive for 7 witnesses. What is everyone's thoughts on that?
Your Honor, do you want to hear from the plaintiff first or not?
Absolutely. At this point, I kind of open up to everyone. So what, Mr. Hildenbrand, what would you like to tell me?
Well, the information that the prior counsel forwarded to me is 120 pages of who knows what's in there. At this stage, I have not had an opportunity to look at every page, and I apologize for that also. This has been a kind of a last minute thing for me. I'm not unfamiliar with evictions. I'm just unfamiliar with the 120 pages. I don't know that any of those things are really going to be pertinent to a legitimate counterclaim. I don't know one way or the other. But I'm not opposed to setting this out at a time, within reason, for you to accommodate us all in one time as opposed to coming back, back and forth, back and forth. I don't want to do that if we can avoid it.
Well, that'd be my goal as well, but
Yes, sir.
unfortunately, I have personal items coming up on the 24th and the 21st, and I'm taking some much earned vacation time in early September through mid-September. So this is going to be a lot. So I can squeeze in half a day on August 17th from 9 to noon, and then block off some time in the morning of August 31st. Unfortunately, I won't be able to give you guys too much availability on August 24th. So again, I want to give everyone a full and fair opportunity to present all of the evidence that all y'all want to provide, but looks like we might have to do some piecemeal trial work here, unfortunately. What's everyone's thoughts?
Your Honor, I think the first thing would be if Ms. Weir is going to actually call 5 witnesses, it'd be great to know who they are, have an opportunity to question them. That if all that, I don't have any trouble with the 17th, 9 to noon. Is it accurate then you've got nothing that rest of that balance of that week?
I've got tons of stuff going on the rest of that week, counsel.
Okay, it's okay. I mean, it's okay. I just was curious.
Yeah, it's unfortunately, yeah, it's just the nature of the beast. So,
Understood.
so Miss Weir, are you available August 17th from 9 to noon for bench
Yes.
trial? Okay. All right, so we're gonna bench trial schedule that before me in person on August 17th. We're gonna start at 9. We'll go to 12 noon. Hopefully we get hopefully we make great progress. I can also block off some time for all y'all because again, I want to make sure that everyone has full and fair opportunity to present your evidence. We can I will block off August. Does August 31st from 9 to noon also work for any thing else that we may need to, any other follow-up witnesses or anything else to wrap it up? So you're getting basically a full day's worth of bench trial. It's just broken up rather ham-fistedly because of my schedule.
Okay, I'm okay with it.
I'm fine with that, Your Honor.
All right, so follow-up trial. So again, it's the same trial, but let's also block off Monday, August 31st, in person, 9 a.m. to noon for any wrap up, any witnesses that we don't get done on August 17th. So I'm going to order, we're going to use Case Center for exhibits. So exhibits to be uploaded using the Case Center system. My clerk, Drew, will have the minute entry language or the use of Case Center, but I want all exhibits uploaded no later than 5 p.m. Thursday, August 13th. So you have a week. And then any disclosure statements, disclosure of witnesses and exhibits to the opposing party and witnessed and disclosure statements to be filed August 11th.
Your Honor,
Yes, sir.
May I be heard on that issue?
What would you like to be heard on?
The idea of receipt of those things to me, from the defendant prior, and I don't have any trouble doing the same, prior to the August 11th, date, rather than just having a deadline for them to be uploaded and filed. I'd rather receive them if you're open to that.
That's
No,
what I
it's
said about the 11th. The 13th is to upload to Case Center.
So you're saying exchange them by the 11th?
Yes, sir.
Okay,
I thought it was, can I speak?
Well, okay, well, if I was unclear, I want the parties to upload their final exhibits to Case Center by Thursday, August 13th by 5 p.m. Now
Okay.
disclose
And
it.
then statements.
Now
I'm sorry.
disclose everything amongst the parties, witnesses and exhibits, list of exhibits amongst the parties on August 11th. Also, I'd like you guys to file your statements that same day on August 11th.
Okay.
If I was unclear, I do apologize.
thank you. That's.
We're dealing with
fair.
very quick turnarounds, and Rule 10 doesn't really contemplate such things, but I only think it's fair. Okay.
Yes, sir.
All right. Anything else? Anyone else want to bring to my attention before we come back on the August 17th for bench trial?
No, sir.
Ms. Weir? You're on mute.